Afternoon, everybody. Hi, you know me, I'm Herschel Conyers and the current chair of JJI. And I think we've got something really exciting going on here today. So I want to introduce the three people who will be presenting from the National Juvenile Defender Center. Jamie Michael, who is the research manager, Carly Linoff as the research fellow, and Marianne Scally as the executive director. And they have spent since 2020 putting together this report that they are going to share with us today. They have interviewed public defenders from some 50 plus public defenders from some 38 states. The report is heartening and depressing at the same time, which is the space we often find ourselves in. But I want to thank them personally for the efforts and putting out there what I think some of us know. And they will report, we'll do some Q&A, and we'll do some breakout where we can try to take a deeper dive into this issue. So without more due process in the time of COVID, lessons and reflections. Thank you, ladies, for being with us today.
Thank you. Thank you for asking us. So again, we're here today to present our findings from a study we conducted last summer during the pandemic. The purpose of the study was to investigate the impact of COVID-19, the pandemic, on the experience of juvenile defenders and their clients. We began conceptualizing the project back in May of last year. So the pandemic started in about mid-March. And after a couple months, we heard a lot from defenders in the community who were really struggling with all types of challenges that the pandemic presented for representing their young clients. And so we wanted to figure out a way to systematically investigate that, to capture what those issues were so that we could figure out ways to better support juvenile defenders, both during the pandemic and after. Oops. So in terms of our study goals, the first goal was really to highlight the experience of juvenile defenders as first responders. The role of juvenile defenders is to advocate on behalf of their clients, in particular their clients' liberty interests. During a pandemic, there's more at stake than liberty interests. Health is at stake, particularly for young people with preconditions. Yet advocating for their clients, for defenders, meant that sometimes defenders had to put themselves at risk for contracting the virus, passing it off to their family, or even passing it back to clients or other clients. I remember at just one point here, there in one of the interviews, there was a comment from a defender sort of drives this home. And he was talking about how just it's kind of crazy, the calculus that kind of had to go through his mind when thinking about whether or not to take a client, take a case to trial, to in-person trial, and that it came with an enormous risk to both his health and safety and the health and safety of his client. And that had to be a part of their calculations in taking a case to trial. So we really wanted to hear from defenders, what were the health and safety issues that they were experiencing and the health and safety issues of their clients. And to highlight this idea that defenders during this pandemic and even sort of beyond the pandemic were really working as first responders and helping youth navigate this crisis in the court system, in the delinquency system. We also wondered how the pandemic, we wanted to hear from defenders how they thought the pandemic was perhaps magnifying disparities that already existed in the delinquency system. And also how issues of equity might play out in regards to this shift to remote operations, to remote justice. And finally, our last and probably one of the biggest study goals was we were concerned with how this shift to technology-based communication would impact legal representation. Pre-pandemic, there were jurisdictions that used video conferencing in juvenile court. We were aware of this. And as an organization, we have always been critical of the use of video conferencing in juvenile court. Usually in our discussions, or I think there even have legislative testimony about this, talked about legal arguments, but they've been primarily legal arguments. And also sort of talking about the technical difficulties, right? Just highlighting the technical difficulties that can occur when a defender is trying to represent a client who's not in the same room, or if the defender is in the same room with the client, how the defender, the conflicts that can come up, or the technical difficulties that can come up when the defender isn't in the same room with other court stakeholders. And so as we were conceiving this project, right in the midst of the pandemic, when the whole world was turning remote and having to really struggle with how do we do this, and what are we losing out on when we switch to sort of technology-based communication, we realized that there was more recently had been research conducted on this field of what's called mediated communication. And I believe, Carly, that there are a few pieces that we will put in the chat for folks. A couple pieces from the NLADA, another defender organization for adults, and the Brennan Center. And they're essentially reviews of some of the empirical research on video conferencing. Now, interestingly, there's not a lot that's been done in the legal context. There are a few studies looking at immigration, looking at bail, but most of the research that really talks about the process, right, or how it's different between in-person and technology-based communication, they're mostly done from the business world. So there's these experimental studies looking at business issues or business problems. So like interviewing for positions, or collaborating. I think collaborating is definitely probably one of the main sort of topics in this research field. So what these studies, interestingly, have shown us, are what we started to learn as we were looking at the studies and talking to researchers, is that when we are communicating, there are these nonverbal cues like eye contact, like body language, like tone, and we attend to those when we're communicating with somebody, and when we're doing it through technology, so through a computer, through video conferencing, or through a phone, they're different. We don't attend to, in fact, we don't attend to the same cues, or those cues are limited or distorted when we are communicating via technology. So it is different, and there is something that's lost. And these cues really impact how we perceive people, how we judge people. And so they're important. So we wanted to understand from defenders how they were experiencing the shift to technology-based forms of communication, especially video conferencing, and how they felt it impacted their ability to effectively represent young people in the courts. So in regards to our methods, again, this was a qualitative study. We interviewed 51 juvenile defenders from 38 different states, including DC and Puerto Rico. And these were all folks who were part of the NJDC network. They were all specialists in juvenile defense. And we really, really thought that this group of people could really help give us some important insight into just the experience during the pandemic, and how it was affecting how they represented young people in the court system. We did phone calls, 45-minute interviews conducted by phone. We had about 11 open-ended questions. The questions were fairly generic. And we didn't ask folks things like, do you see yourself as a first responder? We generally just sort of asked if they had any concerns about their own health and safety when they were representing young people, or if they, and what the concerns were for the young people, what concerns they had for the health and safety of young people, and what the young people were saying themselves about what was concerning them during the pandemic. And we also, again, in the same thing with technology-based communication, we didn't specifically ask what their obstacles were that they experienced. We just asked, how has communication changed during the pandemic? How have court procedures changed? And how do you feel about those changes? So we really wanted to kind of just leave it open to hear what folks were experiencing without sort of our bias there judging their perceptions or their experience. So they could just sort of give us their opinion, their honest opinion of what they were experiencing. And there were a lot of differences all over, because some people were experiencing a hybrid environment where some court hearings were in person, some were remote, some were entirely remote, and some were still in person. So there were definitely a number of experiences, but by far, when we did the analysis, the key themes that emerged was that, first of all, the issue of this idea of first responders. There was a lot of discussion around the health and safety risk, both to themselves, but mainly concerns for the health and safety of young people during the pandemic. And the other key theme that emerged most frequently was this struggle with technology-based communication and how it negatively impacted the representation of young people during the pandemic. So it's this, because that's the topic for our talk today. Carly is going to go into our findings, but really focus on the findings regarding what defenders' experience was with technology-based communication and how they felt it impacted their ability to provide effective representation for young people. So Carly.
Thanks, Jema. So when we talk to these 51 defenders and when we talk to them about virtual solutions specifically, one theme that ran through almost every single interview, if not every interview, was this one. And one of the defenders we interviewed just summarized it so eloquently. I didn't want to change anything they said about it. I just wanted to use their words. And that's that virtual solutions presuppose that a young person has an email, access to video conferencing applications or software, the means to obtain the tools necessary for appearance, and technological savvy. Technology-based communication presupposes a position of privilege. And this defender was speaking specifically to something that in research is typically referred to as the digital divide. Now, the digital divide is a term that refers to the gap between those who have access to broadband internet and the technology to actually use that broadband internet effectively versus those who do not. And research has demonstrated that just as a matter of statistics, Black and brown communities, rural communities, and communities that have lower socioeconomic status tend to, just as a matter of fact, not have robust access to these types of things. And these are three pretty broad types of communities, but these are communities that I think we all know a lot of our clients, a lot of our youth come from. And so it puts individuals who live in those communities at a distinct disadvantage when it comes to communicating through technology-based means. And our field is one that trades pretty extensively on communication. So as a result, being on kind of the short end of the digital divide puts individuals at a distinct disadvantage when it comes to engaging with the legal system and remote justice specifically. Defenders specifically cited issues around confidentiality, around just technical limitations that may have predisposed them to ethical issues, and also just the ability to connect with clients and other court stakeholders on a human level. So let's start with that first point that I touched on, just attorney-client communications. And we know that rapport building is very important, particularly for defenders with their clients. And rapport building starts in the field. You can't build rapport unless you're talking to the person you're trying to form a relationship with, right? And as a lot of defenders that we spoke with, most defenders that we spoke with really noted that simply even just getting in touch with clients was difficult. Either clients lacked devices, or if they did have a device like a phone or a tablet that allowed them to communicate electronically with their defender, those devices lacked reliability, either a bad connection, no camera, no minutes. It was difficult for attorneys to get in touch with their clients. When defenders could get in touch, the opportunities for contact were tended to be less personal, or were described as less personal and less confidential than those that would have been done in person. And this became a very important point for ensuring confidentiality. Confidentiality is a pretty unique tool in an advocate's toolkit when it comes to building trust in clients, especially when you're engaging with younger clients. And defenders repeatedly expressed frustration to us when being interviewed that they found it difficult to ensure confidential communication. They couldn't control the environment. They didn't know for sure who else was in the room outside the scope of the camera. And this was repeatedly raised, particularly with regard to youth in secure facilities. Defenders expressed concern that correctional officers would insist upon remaining in the room if the youth was going to be using facility computers to have a video conference call, or even if they were just on the telephone. Adult gatekeeping of communications or intrusion into confidential conversations was also an issue for youth not in custody, especially if the youth didn't have a phone, but their parent or guardian did. But this was very much a really striking concern for defenders who had youth in custody and who really needed to be able to have frank and confidential conversations with their clients that they didn't feel comfortable having because they didn't know who else was in the room. And so this overall decrease in attorney-client communications, as well as some of the expressed feelings of reductiveness or impersonality that sometimes accompany technology-based communications, made it difficult in the defender's perceptions to build trust with their clients, build rapport with their clients. And the struggle to build trust often reflected in defenders feeling as if they weren't able to obtain the information they needed for hearings. So let's talk about communications in hearings. The digital divide was brought into even sharper relief for a lot of defenders that we spoke to when it came to communicating with clients in hearings. One defender relayed anecdotes of trying to do dry runs with his clients so that the clients, they could just get acclimated to the technology, kind of get familiar with it, see what it's like. And as he was doing these dry runs, particularly early in the pandemic, he realized that most of his clients lacked a tablet or a phone, and simply couldn't call in. And even if they did have a tablet or a phone, they weren't used to using this type of technology. I think it's really important to note at this time that youth use technology in a way very different to adults. In an age of texting and social media, they're not, kids just don't do video calls that often. It wasn't normal before COVID, and they barely ever talked on the phone. That was also not something that was necessarily normal for adolescents to do before COVID. And so even if they could get on the hearing, they weren't accustomed to really engaging in this manner where their face really is being scrutinized and their voice is being scrutinized via technology. And so that caused that it became very difficult to communicate, because the arsenal of tools that a defender would typically use when having this type of fluid communication with a client, say, a nudge to the shoulder or a pat on the back, just weren't there. And you couldn't exactly lean over to your client and whisper, hey, you need to look at the video camera, because you can't lean over, there's nobody there. And so those little ways of communicating, those little ways of trying to make sure that that the kid was going to have as smooth a hearing as possible, suddenly was not available to defenders. And there was a lot of scrambling and a lot of creative solutions to this, but nothing really substitutes for those in-person kind of micro interactions. There were also technical limitations to hearings that raised ethical concerns for defenders. At least one defender relayed an experience to one of our interviewers about being very concerned about what the record was reflecting in hearings, because their objections would literally go unheard because the video client that they were using could only handle one microphone being active at a time. And so it was very difficult then to raise objections in a timely fashion, because that defender essentially had to wait until the other party was done speaking before they could literally be heard. There were also concerns expressed from advocates over access to or recording of breakout rooms when it comes to confidential communication with their client. And many defenders expressed as if they felt like they had a choice between communication and confidentiality. And that is not a tenable, frankly, it's not a tenable position for defenders to be in when you're engaging with these types of hearings, especially when your client's liberty is at stake. Defenders uniformly expressed that they felt as if these obstacles had a direct impact on their ability to provide effective representation, robust representation, and type of representation they thought that their client was going to be happy with. And so when it came to virtual hearings specifically, defenders cited concerns with their client around comprehension, the ability to understand what's actually going on in that hearing, the ability for their client to communicate questions and concerns to them in real time, because communication is a two-way street. A client needs to talk to an attorney as much as an attorney needs to talk to a client. And overall, the one of the biggest concerns that defenders expressed was that virtual hearings run a very real risk of dehumanizing their clients. Jamin, I thought it would be rather funny. I don't know if any of you are familiar with the screen cap on this slide with the cat. A lawyer didn't know how to turn the Zoom filter off on Zoom, and so showed up with a very photorealistic filter of something not human over his face. And it's funny. It is funny until you kind of think about it for a second and realize this is kind of what virtual communication does, right? It flattens interactions. You're looking at a screen. You're not necessarily looking at a human standing in front of you. And a lot of defenders really express concerns over their own capacity to express passionate arguments, zealous defense to a fact finder over essentially a TV screen, and the saliency that maybe an in-person hearing, physical presence would have that virtual hearings do not. And I know that Jema touched briefly on about collaboration in virtual settings, particularly kind of in the context of business and in negotiating and trying to get things done. And one of the things that research demonstrates is that when you're using mediated communications, whether that's a conference call over the telephone or something like Zoom or Skype or WebEx, the individuals who are on separate sides of the call, who are not physically in the same room, it's actually harder to negotiate because the parties will take more extreme positions than they would have otherwise. And for any of us who have sat in a juvenile courtroom, we know that that's not where we need to be, coming from extremes and coming to the middle. And to have that sense exacerbated, even inadvertently, it runs a very real risk for the capacity for defenders to do their jobs. And the very last thing that defenders were concerned with were the fact that some youth, some of their clients just didn't want to engage in virtual hearings. And especially in the early days of the pandemic, when we were still trying to figure out exactly what court was going to look like, what timelines were going to look like, when there was a lot of uncertainty and case delay, youth got frustrated very quickly. And some defenders relayed experiences to us that indicated that youth's calculus about what they would want to do with their case long-term changed. All of a sudden, kids who wanted to go to trial wanted to take a plea because they just didn't know what was going to happen, and they were not comfortable with this new medium. And so this particular issue, it's not just due to virtual hearing specifically, but communication overall. So given these obstacles posed by technology-based communications, what can we do? I think Marianne might have a few answers for that. Marianne, unfortunately, you're on mute.
Let's try to fix that. Thank you all so much for being with us this afternoon and for taking time to think about these issues about video conferencing and their impact on young people. I have to say we were really excited at the National Juvenile Defender Center that you all reached out and wanted to have this conversation because you're getting ahead of the curve. Right now, we're all still in the pandemic. People are grappling with the need to have virtual hearings because we don't have a choice. But what you're focusing on today is when we do have a choice, what do we do? So we're going to present a couple of recommendations, but they've all come out and they're really where you all are coming from. So first of all, as the National Juvenile Defender Center, our very first recommendation is we hope that courts and systems will recognize juvenile defenders as first responders to youth and youth rights during this pandemic and ensure that youth defenders are accessing PPE. They didn't talk about this. One of the scary things we heard about was many court systems around the country not affording PPE to defenders and clients, either in hearings or outside of hearings. We also want to be sure that when we look at what's happening during the pandemic, that we're affording virtual technology accommodations to young people and to their defense lawyers, and that we're ensuring that they have these accommodations inside and outside of courtrooms, as well as in facilities. You know, everything that Jayma and Carly just talked about matters, and it matters right now in terms of young people's lives and the decisions everyone's making. We also are, want to be sure that we're underscoring that as young people are prevented from engaging with technology effectively, that we as decision makers and advocates can do everything we can to make sure that young people have what they need and work to mitigate the limitations that exist for them. Currently now, we have to also recognize, and this really links to what's going to happen later, what are the due process deprivations that are occurring? So everything that Carly and Jayma just talked about, this infringement on the ability of young people and their lawyers to engage effectively and communicate about the hearing and young people's rights. So we want to be sure that as to the extent we have to continue to use these technologies, that they're private and confidential, that young people get to take breaks, right? How many of you have Zoom fatigue, right? There's all sorts of studies now on how hard this is. How hard is it for a young person to engage with a screen and really grasp the life consequences of these conversations that we're having about their lives? So taking breaks is really critical in making sure that evidentiary hearings aren't conducted ever virtually unless the young person and their lawyer consent. So you're all focused on what happens after the pandemic. So let's talk about those very critical recommendations. So one, first and foremost, our recommendation is that we discontinue all virtual hearings since court convenience does not outweigh the 14th Amendment, due process considerations, and right to counsel. What we're saying with this recommendation is that we hope courts will not have policies that demand virtual hearings for any particular kind of hearing. It shouldn't be a presumption for virtual hearings. It should be a presumption against virtual hearings. If young people file a motion and affirmatively request a hearing because for them, their family, it is actually better for them, then we ask that courts consider the opportunity to have virtual hearings. We also want to make sure that as courts proceed, that the processes and procedures never infringe upon young people's right to counsel. Right now, we know that access to counsel is harder. And we want to make sure that as we come out of the pandemic, that we don't maintain policies and procedures that continue to make it harder for young people. Critically in this conversation, we talked about equality and disenfranchisement, and how this digital divide is hurting our young people, especially young people who live in communities where they don't have access to technology, and specifically Black, Brown, Latino youth who are engaging in the juvenile court system in disproportionate numbers everywhere. We have to recognize the harms of virtual proceedings and do whatever we can. And finally, after the pandemic, services, right? So we don't focus on post-dispo issues very frequently, but as many of you know, services are also being provided now to young people in the virtual space. So we're really focused on rights, access to counsel, liberty considerations, but we want to make sure that as we're coming out of the pandemic, there still is not going to be this idea that we're going to have services provided virtually. So we want to now have space and time for questions. I know that Betsy has 10 minutes built in. Then there are many more recommendations that are in the report. We hope that you'll go to the report and read them. We wanted to focus on those that were specifically focused on virtual technology and virtual proceedings. But please let us know if you have questions. And Betsy, we're open now to really hear from the community that we've got gathered here today.
So I don't know who's sharing their screen. If that's you, Carly, yeah, thank you. If you could stop, it would be easier to see who's on the call. If you have questions, I'm having trouble seeing who's here. So if you have questions, could you please just speak up? And I think I'll start. I was really startled. I had not considered the fact that youth do use technology differently than adults. and don't, and I should have known that because I finally learned to text when my daughters became teenagers because it was the only way I could reach them. They would not answer their calls. So I should have known that. I think that's a very interesting point.
Right, and I think that's really interesting for court decision makers, right? Because we all have this assumption that young people are really fluid with technology and how to manage technology, right? But you think about all the young people in our lives and what it was like to go into this pandemic, learn virtually, be socialized virtually. It's different than being on TikTok and Instagram and all the other spaces they're used to engaging with each other.
We have a question. I was wondering whether there were any specific findings or trends around youth who are English language learners or who have disabilities.
Carly or Jema, do you guys want to take that? I know that we had some input on young people with disabilities. I don't remember about English language learners.
Yeah, I mean, I think there definitely was some mention about frustrations around, you know, how to work with interpreters. I think the frustration around disabilities was primarily, you know, defenders feeling like if the only mechanism through which to communicate with young people was a telephone, because oftentimes they didn't want to do video conferencing because they were concerned about confidentiality, particularly if a youth was in a facility. So they were concerned that there was this difficulty in being able to assess whether or not, or if a young person had disabilities, the extent to which those disabilities impacted the young person's understanding of sort of what was happening legally. So that was sort of where the focus went in terms of disabilities. Hopefully that answers the question.
I think, you know, English language learners and young people with disabilities, my general sense, of course, is that for those young people, it would give us even more reason to be careful about our use of virtual technology and communication, right? We all, in terms of thinking about how to, you know, enhance young people's capacity to engage in their own defense, overcoming any barriers at any time is important, but adding an additional barrier and an additional layer to that seems contradictory to what we want to achieve.
So I don't see any more questions in the chat, and I know folks are eager to hear the panelists respond. Scott?
I do have one quick question that I did want to ask. Before we got started today, Marianne, I think it was you that had mentioned that NJDC has sort of been in the waters of thinking about concerns surrounding virtual hearings since 2020 or 2000. For 20 years now, you've been thinking about this. How has that thinking shifted or changed? And was there anything in particular about sort of the experience of the past year that was more alarming or more concerning, or like is it the same concerns just within a different sort of moment, or are those concerns growing, or have we has the thinking shifted from NJDC's perspective as you've continued to think about this issue through a couple of generations of kids going through the system?
That's a good question, Scott. Of course, 20 years ago when we started being concerned about video detention hearings, it was really, technology looked really different, right? So we didn't have Zoom and FaceTime. It was much clunkier technology. And so the dehumanization was what jumped out at us immediately in those contexts. But to see how pervasive the use has become because of the pandemic just raised and rings so many alarm bells for us as a community, because it is easier not to travel. It is less expensive not to travel. It can be more efficient to sit at your desk at home. And what really, I think, changed in our thinking, or I should say grew in awareness for us, was that we as a community recognized how critical those in-person, face-to-face interactions are with young people, that human engagement It is really different. I mean, this conference we're having today, if we were all sitting together and talking to each other and sharing food and having coffee and a drink together and having side conversations, we would learn so much more about what we're each doing and how our role in this effort and how we're each engaged in it differently. And we could do so much more. When you think about what that's like for a young person to have their life decided on a screen where no one is learning any nuanced information about who they are, and where no one has the real ability to see all their strengths and their beauty come through on a screen. I think for us, we are working harder. It's why we decided we thought it was so important to do this analysis to figure out, what does it look like for young people? What does it feel like for young people? So our gut response 20 years ago, as I said earlier, there's more, Jema, empirical research?
Yes.
That's the word I'm supposed to use, to help us understand. But it's, you know, like Sotomayor and JDB, it's common sense, right? Like what this is for young people is not what it should be. And we all have the ability right now to make sure that these strategies, which we know are not beneficial long-term for young people, don't hold on simply because it's easier.
And I would just also highlight the fact that sort of the new research that's been coming out in the mediated communications world, it's a different experience. And it is a little bit alarming when you read the research, and it talks about how the impact of mediated communications on perception, on judgment, on impression formation. I think that's something that we really, really need to attend to, that I think just sort of drives the point home even more. There are things sort of beyond what we are usually aware of when we are interacting with people, whether it's, you know, comparing in person to technology-based communication. So I think the research, the fact that there's research now makes it sort of even a scarier concept.
That was a great question. Thank you for your answers. So Scott, do you want to take it away?
Sure. And I mean, I guess sort of on that same note, like, we're also so lucky to be able to have you all here, part of our conversation, despite the fact that, you know, folks are in DC. I feel like I'm seeing somebody who might be in Florida. Like there's, you know, we are able to come together and talk about this and sort of thinking locally, but, you know, we're able to pull on the experience and expertise from you all. So thank you very much. And I don't want to talk. We have 3 great people that Betsy has lined up for some sort of local and sort of various perspectives in response to what you all just talked about. And I wanted to start with Amanda, who, there you are, Dr. Amanda Klonsky, who has been in this field for over 15 years, dealing with youth in institutions and corrections, and would love to get some of your thinking and feeling. And I'm not going to do full-on introductions because we have a very short window.
Great. Thanks so much for having me. It's an honor to be here with all of you. I'm an educator, so I bring a very different perspective and set of experiences than most of you do, who are attorneys and who do the important work of representing our students and young people in the courtroom. I started as a young teacher in the Cook County Juvenile Detention Center longer ago than I care to admit, and longer than Scott indicated, but no need to confess the real numbers here. And so I went on to become an education researcher, and I write about young people in detention and in confinement, in particular about their developmental and educational needs. And I teach here at University of Chicago in the School of Social Work. So in reading the, I think, very important report, I want to respond as a teacher and as somebody who knows about youth development. And first of all, I want to say it's interesting to me to be engaging with all of you about this right now, because we're having the same parallel debates about education and virtual education, online education, as the pandemic pushed schooling online for children all over the world. Children in confinement in particular, we're finding the move toward privatization, toward for-profit education companies in particular, seizing this opportunity to really expand their programs inside of detention centers and juvenile prisons. We're seeing big concerns as educators about this expansion, because we know a first principle of good teaching and learning anywhere, right? Not only in the case of working with young people in jails and prisons, but anywhere, is that all people learn in relationships with others, right? With other people. Right? So consider that for a moment. Dr. James Comer said, no significant learning happens without significant relationships. And so I'd like to extend that metaphor to the courtroom, where the system is implicitly asking lawyers and judges to help guide children back onto a path of safety and support. And yet we've designed a court system and a system of punishment that's in direct conflict with these principles of youth development, good teaching, or the commitment to helping children grow and change, which I hope is a shared commitment that at least everyone in this room brings as our first principle of engagement in the work. So rather than creating a system of continuous care in which children are known and can grow in their relationships with people who know them and care about them, we've created a system that's isolating, that removes young people from their families and those who know them best, and in which we hardly have the space to get to know the children in our care. So I want to echo and underline what Marianne said earlier, that to be known is even more important for young people in detention or prison than it is on the outside. And that was true before the rise of virtual hearings, and that the pandemic has escalated this problem. As we've heard from public defenders whose time and resources are already incredibly strained, now there's little to no opportunity for confidential communication and preparation for or during video hearings. Children are often brought into the supervisor's office to communicate with their lawyer, that they can't be left alone there. So someone from the facility is likely listening in to all these what should be confidential conversations. As Carly Lenhoff raised earlier, this impedes on the child's sense of trust in their attorney and the ability of the lawyer to build a strong relationship with the child. So I want to review what we know about youth in confinement. First, we know that very often they've been out of school. Young people in detention or prison come to us with highly interrupted histories in school. They've often been out of school for long periods or have attended multiple schools while being passed from foster placement to foster placement, or because they faced disciplinary measures in one school and got reassigned. When I worked in Chicago public schools, I frequently pulled the enrollment records of students in confinement only to find that he or she had been enrolled at Nancy B. Jefferson, the public school in the detention center, 30 times by the age of 15, right? But attended no other school for more than a few days or weeks. In these cases, somehow the school inside of the detention center has become the primary site of academic engagement for this child. And there are thousands of students in Cook County alone who have these highly disrupted histories in school. So this means that very often their ability to read and write or understand court-related materials is limited, right? Number one, right? Number two, we know that young people in court come to us with high rates of trauma, learning disabilities, to the point that was raised earlier, and high rates of mental illness. Linda Teplin and her team at Northwestern University have produced a very important body of research that tells us that these young people have experienced rape and sexual violence in high numbers, including boys, by the way. Her research also documents that our students in confinement have recently experienced violence and other major forms of trauma, and most are experiencing post-traumatic stress. And this trauma and stress can compound other learning challenges and further impede upon a child's ability to understand what is happening in the courtroom, especially in the absence of a trusted adult to guide them. So the lawyers who spoke earlier talked about the need to give someone a nudge or ask them to stand up straight or look at the judge. But I want to underline that young people may not understand at all what is happening, right? For a variety of reasons, including cognitive issues or learning disabilities, and that without that trusted adult there, we're sending young people into court without advocacy, right? It's not fair. Third, we know that these young people have very few healthy, stable relationships with adults who know them in the first place. And because they are so off track academically and have such highly interrupted histories in school, very often no one really knows the social, emotional, or academic needs of this child. If they have an IEP for their disability, it's very often out of date or inappropriate. We don't know about their basic skills in math, literacy, etc. And most importantly, we don't know them. We don't have the time to learn about their experiences, their interests, their passions, the things that might motivate them to grow and change. And virtual meetings with lawyers or virtual hearings may even further limit their capacity to develop these critical relationships that could determine the course of their whole lives. So as an educator, I'm extremely concerned about the ways that this move toward expansion of virtual legal services and hearings will exacerbate the inequalities and the crisis that we were already in, and which our most vulnerable young people who most urgently need the guidance and support of healthy adults have the least access to those guiding relationships. Thanks.
Thank you so much. And yeah, we will keep moving forward. We have Judge George Timberlake with us, and I would love if you, again, we're not going to go into bios, but you obviously have the perspective of having sat on the bench, but then also through your work with the Juvenile Justice Commission and sort of continued work sort of in this space. I would love to sort of get your reaction and thoughts about what we've heard so far here today.
Good to be with you all today. Good to see so many old friends. This is sort of broad and narrow. The broad part is lawyering is communication. I mean, it's that simple. We can't be advocates for others or for a position without words. But what we've heard today is that communication simply needs a broader definition. It's as Jamie said, it needs to be reformed to include more than just the words we use. It is, in fact, volume, eye contact, body language, perceived privacy by the listeners, perceived privacy by distance from your attorney. When you put your heads together, as has been said earlier today, there is sort of an aura of confidentiality that child or adolescent or any defendant understands that defenders, that person's defender is actually going to protect their secrecy in the process, that is, protect their confidentiality, all of those negative parts of their life that Dr. Klonsky just described puts them at in another trauma. They feel forced to talk about things they might not want to. Not just forced, but that conversation may in fact extend beyond the attorney that's representing them. The elevation of one person speaking to another, that means something. And in all of those types of additions to word communication, we really need to expand the definition. And as defenders, I think you need to be advocates for just that. Let's talk more about what communication is and how it affects your ability to advocate. The other thing that I think has been said, but again needs to be emphasized, age matters. For those of us who've been in both child welfare court and delinquency court, you talk differently to a 6-year-old than a 16-year-old. And that person listens differently as a 6-year-old than a 16-year-old. I don't think that, other than this process here today and the good work that the Defender Center and the Midwest Defender Center has done, I see advocates in the courtroom on both defense and prosecution who simply don't understand that. They haven't heard this conversation. And even though they do it every day in one way or another, that's not part of the definition of communication. You know, if you're a salesperson, you get that. If you are trained, you get that. The person in the courtroom doesn't necessarily have that understanding, and it's necessary for the defense and the court to explain that if it's being affected by the way the court system is being held virtually. I spent 23 years on the bench in 12 counties in the Second Judicial Circuit. For those of you who aren't from Illinois, it's the largest circuit geographically in the state of Illinois. It's the size of the state of Connecticut. And I served in every one of those counties over that period of time. The thing that impresses me the most, and now I'm semi-retired, but my wife and I have no children, but we have 40 plus nieces and nephews, and somebody's always in trouble, and call Uncle George. Counties and circuits operate differently just because they're separate. And if you're going to make an impact on the education for the court, perhaps, the judge, and the prosecutors, you have to speak locally. You have to know what it takes to impact all of those court system participants to change things. Now, those 12 counties in which I served are extraordinarily rural. The largest city is no more than 18,000 people. Every one of those counties operates differently. And as I've been representing my nieces and nephews around the state of Illinois, I'm more convinced of that than I ever was. Local makes a difference. And in the case of these rural counties, it is what broadband? You know, certainly, if you're in the city and simply don't have access, don't have the wherewithal to have a tablet or a telephone, that's one thing. On the other hand, in many parts of our country, everywhere, there are places that simply don't have broadband access. That's a different kind of advocacy that impacts whether or not we do virtual hearings. Now, I'm not attempting to say that we should have more of them. For the last 10 years, Betsy and Veronica and Herschella, we've been battling back against virtual hearings from detention centers. It's always a topic. There's always a bill. Let's do this because it saves money. That means I think that you have to recognize who the decision makers are around the subject of virtual hearings, and you have to make friends with them in one way or another, at least engage in that communication that we've all been discussing today. That may be a county board member, it may be the state's attorney, but somebody there has the decision-making ability to change things. Certainly the chief judge in your circuit or county, they should be approached. And I want to, I don't know whether Justice Burke is still with us, but the Illinois Supreme Court has developed a committee on access to the courts, and they've been doing a great job over the last 3-4 years in trying to provide indigent and those who can't afford anything else to do it themselves, to actually support the pro se part of our court system. Those people need to be communicated with. They need to understand what we've said here just today and to go forward. As defenders, I think it's important for you to advocate for yourselves, certainly around the healthcare issues that we're talking about, but more so about explaining what does it take to be a defender when you have inadequate resources, when you don't have staff, when there are no investigators, any of those things that are out there. You need to advocate for yourselves to those same decision makers that I just mentioned. That's the important part. There aren't many legislators or county or city board members who understand what you do, and therefore they just keep doing what they've been doing. We all have an opportunity and an obligation, I think, to educate, to communicate with those decision makers as well as to our clients.
Thank you. Thank you so much, Judge Timberlake. And sort of a table setting point there to those who aren't aware, Illinois has 16 detention centers for kids, and we have 102 counties. So there's obviously a lot of geography, a lot of places where there's going to be a great distance between where court is happening versus where a kid is being held. And so there will always be pressure sort of arising to come up with new ways or ways to simplify the process and streamline it. So our last person that we wanted to get some response from was Veronica Williams, who was doing some excellent listening and head nodding. So I really would love your thoughts about the report itself, but also what you've heard from Dr. Klonsky and Judge Timberlake as well. What were the things that really sort of stuck out to you? And you're on mute.
First of all, I'd like to thank the panel, thank Betsy and the NJDC for allowing me to speak and the opportunity to speak on behalf of our children who have no voice unless we speak on their behalf. I'd like to reiterate on the point that I'd like to point out is that one, I am speaking as a mother. I'm speaking as a parent and an advocate who within the last several years was directly and adversely affected by a loved one being in detention. Putting our children in a detention facility under the age of 13, our youth, or even our emerging adults in a detention facility is detrimental. We face that as family. We did go through that. Often as parents, we're helpless to help and oftentimes hopeless to hope. However, surrounded by loved ones, as it was stated, and family, the narrative can change and it does shift. But often too many of our children, especially as it was pointed out, our Black and brown children and youth are locked up, locked out, and sitting in a detention facility where they cannot talk or communicate or even say, hi, mom, hi, dad, how are you? Okay. And sometimes they go through mental detachment, which is what we did experience as well. And sometimes they become suicidal, which is not often talked about. That is swept under the rug. No one hears about those things. Okay. So children need to be assessed, in my opinion, as it also was stated, on a case-by-case basis. Okay. And without that, we do lose because of the fact that of the detachment, because of the dehumanizing of the situation. So our duty as a people and as a nation, as a country, should be to protect and to serve our children, family, and communities for a better and safer environment for our youth and for the future. So we must become aware, we must become accountable, and with action, we can repair, restore, and rebuild that which was lost and is broken. The system is so broken. And last but not least, if we have not, or if you already have done so, read the book, Just Mercy by Brian Stevenson. We must learn to do justice, love mercy, and walk humbly with God. And thank you so much for the opportunity for speaking.
Thank you for sharing. And I think, Betsy, I will turn it back to you. Because look at how on time I got that 20 minutes. Like, we're right at 3.
Before we go into the break rooms, I want to thank these terrific panelists. If you had all sat down and planned this together, I know you didn't have the time for that. It couldn't have been more perfect. Thank you for your responses. They were wonderful. And NJDC, in your 25 years, I think this is your proudest moment. This is such a timely, important report. So thank you. So Luis is going to send us into break rooms. We want to get your feedback as an audience. I know this is difficult to just sit and listen online. So what the job in these break rooms is to look at the conclusion of this report. And I'm going to see if I can read it to you right now. We discovered that virtual hearings are impeding juvenile defenders' meaningful representation of their clients and that many defendants fear courts may decide to continue these virtual hearings after the pandemic. The persistence of virtual hearings after the pandemic risks permanently undermining the effectiveness of juvenile defense attorneys for the convenience of other court stakeholders, a systemic deprivation of the right to effective assistance of counsel. And the conclusion goes on to note the very real consequences on not just due process, but also the consequences in terms of the profound racial disparities, which we have in Illinois. 15% of our Illinois population, our youth, are Black African American, but over 70% of the young children who are in detention, 10, 11, and 12, are Black African American. That's about 5 times their rate in the population. Bad for children, period. Horrible where there are these disparities. So we hope that you will look at these conclusions and talk about your reactions to them in the break rooms. And Luis, you're going to send this into 3 break rooms, 4 break rooms? 4. Thank you. Mary Ann, we hope you'll stay and participate.
I was just going to ask that. So should we stay here or should we go to a breakout room? Where are we best placed?
Into a breakout room.
Go to a breakout room? Okay.
Yeah. Thank you.
I'm very, very sadly, Kristen was making an awesome point when the countdown clock, it was like 8, 7, 6, and so if Kristen, for our first beginning, if you'd be willing to sort of restart and share that with everyone.
Of course, we were just wrapping up our conversation about the importance of specialization and judges pushing towards specialization, given the fact that language is so important. And we need judges who are willing to adopt language that needs to be used when addressing young people in the courtroom, and just being more cognizant of what the youth need when it comes to these virtual spaces, and being more, just being more understanding of that, and specialization, and just pushing specialization.
So I made a couple other notes as we were talking, and again, I think group 1, it wasn't an accident in terms of like Louis was very intentional, I believe, in terms of organizing these, we wanted, first we were noting that there are good positive things about the use of virtual hearings in certain situations, but that at least here in Cook, when a matter, whenever sort of there was an evidentiary question, anything sort of substantive in the case, there could be no substitute for being there in person and having live testimony and live the full interactive experience and not virtual. We thought about sort of early in the pandemic, the number one, the first priority was creating safe spaces, actually just safe spaces for people to be. But then that immediately brought out the concerns of dehumanizing the participants, because once we're all in these little boxes, it is a very different way to interact and address. But there were positives that were still coming from even within that fully remote setting, where there were less warrants being issued because kids were showing up more to hearings. And it made, in some ways, system involvement was less intrusive because you were not having to go through the metal detector. You aren't having to sort of have those sort of one-on-one experiences with law enforcement. There was something that was, in some way, it could be beneficial in certain ways. Our big key takeaways, the word that was repeated the most was humanizing. that we want to create a default that our system should always be humanizing first and foremost. And that does not rule out the use of remote where it could be beneficial, but so long as like the guiding light, the North Star is that we are always humanizing the families and kids that are interacting with the criminal legal system, thinking of their humanity and what is sort of like best for them is paramount. And that will involve some work in shifting. Again, judges get great, awesome robes, wonderfully lovely black robes, and that's important. But we, need to create systems and think of ways to reorient the system where it's not central around their time and their space, and we need to be thinking more broadly about everyone and the humanity of each and every player within our the criminal legal system. And that, again, begins with thinking about the kids and their family members who are system involved. So those are the big takeaways from group one.
Anybody else from group one want to add? Group two?
Betsy, I was in group two, and I'm going to start with Roberta, and she can share, because I thought she had a good takeaway.
I guess my takeaway was, I really agree with you, Betsy, that we were looking at, at least I was, and I know a lot of my counterparts are looking at the communication. I assume kids were tech savvy and would really enjoy remote hearings and communicating that way. And it seems to me that they don't. It's a whole different perspective. It really dehumanizes it. I remember a client saying, "You're the first person that's ever shaken my hand," and things like that. So I think it's very important that we go back to in-person hearings as soon as possible. And realize that, kids, they communicate in a different way than we do. When we text, we're doing one thing. When they text or they do TikTok or something like that, they're doing something else. And it was brought up that we would hope that they would make better decisions on what they posted online. Don't be on probation and show yourself at a party drinking or with weapons or marijuana, things like that. So, they're using social media in a much different way, or digital media in a much different way than we are. And to keep things confidential and able to be successful for our clients and give them good outcomes, we need to understand how they communicate that way.
Anna was finishing up when the evil clock started to count down. So.
Yeah, the only thing that I added to that communication, I guess, is my observations that it extends to all sorts of people in the system other than just the clients who misuse technology or maybe aren't able to really communicate that well. And for me, I think it interferes as well with any kind of effort to negotiate something with opposing counsel when they are kind of hiding behind email and don't want to pick up the phone. I think it's the same kind of process that we see with kids that are, using texting. I mean, maybe that, my hair color might give you an idea of how I'm more, phone savvy maybe. But I think when if we ever get back to actually being in a building together, we can actually talk to opposing counsel, try to get to some kind of disposition that might be rational.
I'm hoping she's still on the call. Let me see. We have a visitor from Michigan. Where's the attorney from Michigan? Is she still with us?
Yes, there she is.
Yeah. I'm
okay.
Here.
All right. Then I will let you share your takeaway because it's important.
The takeaway was just the commonality of the problems with representing your clients, especially we were talking about the clients that were incarcerated in detention centers, and that has its own host of problems with supervisors and people in the room that shouldn't be in the room because of confidentiality. But my takeaway was the commonality especially I'm here in Michigan, that it sounds like there's the same problems, especially for juveniles that are on bond and they're at home and they've got parents who, albeit probably trying to do their best, well, some of them, and being meddlesome, where you can't have confidentiality with your client. You don't know, either the parent is interjecting, they're in the room, they're in the camera space, or they're just other random people that are in the room that you don't even know that are in there that are influencing your clients. So it makes it very difficult to establish a rapport with your clients when you can't have any private space with them, even outside of the courtroom, when you're not in a hearing, when you're trying to do it just before the hearing and establishing with your client. So it's a common problem, which I obviously don't have the answer for. But it's good to know, and I put that in quotes, that it's not a Michigan problem, that it sounds like definitely for you all in Chicago or Illinois, that it's also a mutual problem.
Yeah, and who else, who was in the room? Who else was there? Come on, you know who you were.
Well,
all right. So my takeaway was that, you know, we got to do it again. We got to talk more. We can keep talking about this forever, you know, and we can get it right, but we must fight at all costs this notion of remote for our children. It's just not due process. It's just not right. It's just not fair. And we can only expect negative outcomes if we endorse this in any sort of way. That's it.
Sheila, that's a terrific note to end this on. I am a little surprised, though, that one thing that hasn't come up, and we're running out of time, but one thing that hasn't come up is the ability of the judge to assess the well-being of the child when the child is in front of the judge. And I wonder if anyone wants to comment on that, since we do have George, if you want to comment on that, or something that I would think would be terribly important, very difficult to assess well-being over Zoom.
I think that's absolutely accurate, you know, and particularly when you're dealing, as I mentioned in before, different age groups. You know, you can see what 8 or 9 year old, a 10 or 11 year old, you can see how they're feeling. And then the judge has the opportunity to communicate more effectively with that age group. But it's not the same thing as a defender talking to a client, but it certainly does affect the thought process of that judge. And you know, facial expression of a child is extraordinarily telling. Now, you may get it wrong, but when you get it wrong, you ask the question, what are you thinking right now? Is there anything bothering you? Is there something we could do differently? Who would you like to have here with you? All of those kinds of things are meaningful, and you don't get that over a video.
That's great. Thank you, George. So as we end this, we have been recording it. We will share the recording first with our wonderful authors of this report at NJDC to make sure it, for you all to use it. I'm so grateful for this NJDC community, so grateful for the Midwest defenders, so wonderful to see everybody, so grateful for our great community of advocates here in Illinois. Thank you all. This is very timely, and now we'll just all get this message out and this report out. Thank you, Mary Ann. Thank you, everybody.
Thanks.
Thank you.
all.
Somebody call my name.